Welcome to the lecture for Module 10. As you know, this week's module is entirely dedicated to child abuse. However, after we spend some time learning about the definition of abuse, we're going to compare and contrast it to accidents and to neglect. In this lecture, we're going to again cover New York State law. We're going to have just a brief reminder on parents and people legally responsible, a statistic. We're going to cover the definition of abuse, examples of abuse. We're going to discuss two recent cases in New York State, and then we're going to look at some examples where you're going to decide whether the parent had an accident or is guilty of committing neglect or abuse. So let's get started. As we discussed last week, when we covered modules 9, 10, and 11, we're focusing entirely on New York State law. I think that's important because that's where we're going to college, that's where we're living right now, and that's very likely where we're going to be practicing. Of course, if you move to another state, and especially if you move to a different country and you're going to be practicing in this field there, it is critically important that you know the applicable laws, policies and standards in the state or country where you're working. But for now, we're going to focus on New York State. Remember in Module 9, we covered child neglect and the statewide Central Register of Child Abuse and Maltreatment, what we call the SCR or the Child Abuse Hotline. This is Module 10. We're going to focus on child abuse. And next week in Module 11, we're going to spend some time on child protective services, mandated reporters, and the difference between criminal and family court and why a case may go to one, the other, or both. Reminder from last week, the statewide Central Register can only accept reports of child abuse if the child is 1, under age 18, and 2, the alleged perpetrator of that abuse is a parent, a guardian, a custodian, or any person 18 or older who has regular and meaningful caretaking responsibilities for a child. Remember, we talked at length that the SCR is really trying to capture cases involving parents or people in parental roles who are alleged to have abused or neglected a child. So if a stranger to a child physically or sexually abuses that child, the SCR cannot accept that report. That case has to be managed by law enforcement. The New York State Legislature put in law that the SCR can only accept reports of child neglect and child abuse for children under age 18 and against adults, alleged perpetrators who are the child's parent, their legal guardian or custodian, or any other adult 18 or over who is legally responsible for their care. Just a quick statistic for you. Of the 195,000 reports accepted by the SCR every year, remember that was our total number of reports from 2019, 195,000. Approximately 95% of those reports are about neglect. 95%. Why? Well, as you're about to learn, the definition of child abuse in New York State is extremely narrow, and it only includes the most egregious acts, including homicides. In other states, the definition of child abuse may be much different, but in New York State, the definition of child abuse is extremely narrow. So you'll learn why in the next few minutes why 95% of the reports accepted by the SCR in New York State are about allegations of neglect as opposed to child abuse. Our definition of child abuse in New York State is a long one, so we're going to break it into 3 parts, and then I'm going to show you a summary of how you can remember it. So child abuse in New York State is a 3-part definition. Remember, our definitions always start the same way. A parent or person legally responsible for a child, remember that's our standard, abuses that child when he or she, here's our first definition, inflicts or allows to be inflicted non-accidental physical injury which causes or creates a substantial risk of death, serious or long-term disfigurement, long-term impairment of physical health, long-term loss or impairment of the function of any bodily organ. So this is where a parent or other person legally responsible inflicts a non-accidental injury on that child that causes or creates the child's death, serious or long-term disfigurement, or long-term impairment of the child's health or the function of one of their bodily organs. Very serious injuries. The second part of the the definition of child abuse in New York is very similar, but you'll notice a slight difference. Here's part two. Creates or allows to be created a substantial risk of non-accidental physical injury to such child which would likely cause. We see the same elements: death, serious or long-term disfigurement, long-term impairment of physical health, long-term loss or impairment of the function of any bodily organ. So the first part of the definition is about inflicting or allowing someone to inflict a non-accidental physical injury. The second part is about creating or allowing to be created a substantial risk of such injury. Here's the third part of our definition of child abuse in New York State. When a parent or person legally responsible for a child abuses that child when he or she commits or allows someone to commit a sex offense against that child, including sexual misconduct, forcible touching, rape, sexual abuse, aggravated sexual abuse, prostitution, child pornography, and sex trafficking. Sex trafficking was added to the definition in 2017, in the summer of 2017. So these are not just descriptions of events. These are words that have legal definitions. So sexual misconduct has a legal definition. Sexual abuse and prostitution. All of these terms have legal definitions. And if a parent or person otherwise legally responsible for the child commits any of the acts against a child by their legal definition, or they allow another adult to commit one of these acts against a child, that is child abuse in New York State. So I know this print's kind of tiny and I never put this many words on one slide. That's why I broke it up in 3 parts for you. But if you look at all 3 parts on the same screen, you really see how serious the conduct has to be in order for it to qualify as child abuse. We're looking at death, loss or impairment of a bodily organ, long-term impairment of physical health or disfigurement, and very serious sex offenses. So here's how you can summarize the definition, because it's quite long. A parent or other person legally responsible for the child kills the child, almost kills the child, causes serious, permanent physical injury, places the child in substantial risk of death or permanent injury, or sexually abuses the child. And of course, our definition includes that a parent or other person legally responsible allows another person, another adult, to do any of these things. So that's just kind of a way of summarizing our definition. But remember, this 3-part definition is the complete definition of child abuse in New York. This is an easier way to remember it. So let's consider some examples of child abuse. A parent or other person legally responsible for the child. The infant's head is intentionally banged against the floor. The infant's skull is fractured and the child dies as a result of the injury. Well, this one's pretty obvious. It perfectly fits our definition of abuse in that this parent or other person legally responsible inflicted non-accidental physical injury which caused the child's death. That fits our definition very easily. Here's a different example. A tub is filled with scalding hot water. The adult intentionally dips the child into the scalding water repeatedly. The child receives life-threatening injuries but survives. Well, this clearly fits our definition of child abuse because this adult inflicted non-accidental physical injury, which created a substantial risk of death or serious or long-term disfigurement. Burns are very dangerous for all human beings. They are especially dangerous for children and can be fatal and quickly fatal for very young children. So what may be a relatively minor burn on an adult is a very serious burn on a child, and what is a serious burn on an adult is often a fatal burn for a child. So burns are absolutely very serious injuries for children and often result in permanent disfigurement or death. Here's another case. The mother has seen her boyfriend severely beat her child with his fist in the past. Today, her boyfriend intentionally cut the child's face with a knife, inflicting a deep 4-inch long laceration. The child needed over 100 stitches to close the wound. Well, clearly, the boyfriend, if he's a person legally responsible, abused this child by definition. But what about the mother? Well, in this case, the mother did abuse the child by the New York State definition because she allowed another adult to inflict non-accidental physical injury, which created a serious disfigurement. It may seem a bit odd at first when you think about what does it mean for another person to allow a person to abuse a child? It doesn't always mean they have to have put the child in front of the other adult and said, cut his face with a knife. In this scenario, we see that the mother knows that her boyfriend has severely beat the child in the past. Therefore, if she allows that boyfriend to have continued contact with this child, and that boyfriend commits an act like intentionally cutting his face, the mother can be held responsible under the definition of child abuse because she knew her boyfriend was abusive to the child. So even though she's not the person who cut the child on the face, she allowed another adult to do so. That makes her guilty under the definition of neglect. Or I'm sorry, of abuse. I misspoke. Here's another example of child abuse. An adult forces his 14-year-old stepdaughter to perform oral sex on him. Well, if this person is the parent or the step-parent, he is legally responsible for this child, and therefore if he commits a sex offense against the child, including rape and or sexual abuse, then he has committed child abuse under the New York State definition. Here's a different scenario involving a sex offense. The mother is addicted to drugs. She allowed her landlord to take pornographic photos of her child in exchange for drugs and rent. That also fits the definition of child abuse. In example D, we have a stepfather who actually sexually abused his stepdaughter. In example E, we have a mother who allowed someone else to involve their child with pornography. Therefore, the mother committed abuse against the child by allowing someone else to commit a sexual offense against her child. We're going to talk about two recent cases of child abuse, really recent cases. The first one is People v. Parker. That's the name of the criminal case. This case started on December 7th, 2019, when the mother of 3-year-old Major Douglas, she had to go to work. I believe she was a nurse, and she left her son in the care of her boyfriend, Daquan Parker. Now, she had known Daquan Parker for some time. News reports indicate that When she started dating Daquan, she did not immediately leave her son with him. She wanted to be very cautious and careful about who would be left alone with her son. So she actually had Daquan spend some time with her son while her grandmother was watching him. So she wasn't there, but there was another adult, her own mom, who was there present watching Daquan's interactions with her son. And all this had happened without a problem. So in December 2019, when she had to go to work, she allowed Daquan to take care of her son by himself. At 4 p.m. that day, there was a call to 911 in Troy for a child in cardiac arrest. When EMS and police arrived, Parker was not in the home, he was nowhere to be found, and could not be located. The child was unresponsive and was immediately rushed to the hospital. Major died at Albany Med, and when an autopsy was performed, it revealed numerous serious injuries, and Major's death was declared to be a homicide. It took several days for the police to find Parker. When they did find him, he was charged with murder in the second degree, and he pled not guilty. Later, he pled guilty to manslaughter in the first degree. This happened very recently, and you're going to read details about his plea and more details about the case in this week's article. It's also very important to note here in several of the articles I read about this case, they talked about Daquan Parker's criminal history, specifically that in 2017, he was issued an order of protection, a stay-away order of protection for another woman, and he violated that stay-away order of protection. He was found guilty of contempt. That's what they call it when you violate a court order, like an order of protection. And he actually served a year in jail. So if he served a year in jail starting in 2017, he wasn't released until 2018. And in 2019, he murdered Major. Here's another recent case. This one actually happened in Long Island. This is People v. Volva. So Michael Volva was a New York City Police Department officer. He is an NYPD officer, and he and his girlfriend lived in Long Island with 6 children, 3 boys and 3 girls. The 3 boys were Michael's children from a previous marriage, and the 3 girls were his girlfriend's children from her previous marriage. So we've got his 3 boys and her 3 girls living in the house. On January 17th, 2020, Volva called 911 and said that his son Thomas had been waiting for the school bus when he lost consciousness. When emergency medical services arrived, Volva was performing CPR on Thomas. Thomas, 8 years old, Thomas also suffered from autism. When Thomas was brought to the hospital, he had injuries around his head, he had injuries on his face, and his internal body temperature was astonishingly low, just 78 degrees, 20 degrees below normal. Thomas died shortly after being taken to the hospital, and like in the case of Major Douglas, an autopsy was performed and it was determined that Thomas's death was a homicide. So the dad, Michael Volva, Thomas's dad, was arrested, and Angela Polina, who is the girlfriend and the parent of the 3 girls, was also arrested. And the facts of this case are shocking enough, just the bare facts, what's come out in the media about this case. But what was really even more shocking was the couples had, surveillance. They had like security camera and audio around their house and in their garage. And their own video, their own surveillance video, showed that Thomas and his brother Anthony had been forced to sleep in the garage for several nights. Now remember, this is in January. So it's 19 degrees out. The boys are sleeping in the garage on a concrete floor. They're not given a mattress, pillows, blankets, nothing. So I don't believe the video surveillance, the camera showing what happened to these boys. I don't believe that footage has been released. If it has, I haven't seen it. But what was released was the audio. So there's actually recordings that have been released. And when people heard those recordings, they were rightly outraged. So this is just a couple of the things that have been released that was on the recordings. One was an exchange before 911 was called where you hear an unnamed child say, "Why can't Thomas walk?" And Paulina says, "Because he's hypothermic." Later, there's an exchange between Valva and Paulina. Valva says, "He keeps face planting on the concrete." And she responds, "You know why he's falling." And Valva, Thomas's father, the father of the 8-year-old, says, "Because he's cold. Boo fucking who." Later, the audios also says Paulina asking the child's father, "What are you doing?" And he says, "Suffocating him. That's what I'm doing." And she says, "Get your hand off his mouth. There's people everywhere." I I've been working in the field of child abuse and neglect for over 20 years. This case shocked me. The fact that there's actual visual recordings of what occurred and audio recordings capturing what people said before the police arrived is almost unheard of. That is extremely rare for that to happen. So instead of having his version and her version after they've been arrested, we're actually seeing what they did and hearing what they said before they were arrested. And that is extremely rare. So that's shocking. The other part, of course, is just the absolute depraved indifference these adults showed toward not only toward Thomas, the 8-year-old child who died, but also the other boys. This is just some of the conduct that occurred. It's actually much worse than this. So in this week's media section, you're going to read a New York Times article about this case and what's happened since. It is an incredibly disturbing case and one that none of us will forget very soon. So there's quite a bit of research out there about parents who kill their children. But one thing researchers don't look at too often is what kind of criminal sentences do parents get who've been found guilty of killing their children or severely abusing their children. But the research that has been done indicates parents who kill or severely abuse their own children generally receive 25% less prison time when you compare them to strangers who killed children. So parents who kill their own children get less prison time than people who kill strangers' children. I always find this very odd. Parents not only have a legal obligation to care for their own children, but of course they have a moral obligation to care for the children that they've taken responsibility for. And yet when parents murder or abuse their own children, they get less prison time. So why would a prosecutor agree to allow a parent who killed or abused their own child to plead guilty to a lesser charge that carries a lighter prison sentence? Well, one of the reasons is that we have a historical, and I mean going back thousands of years, perspective where people own their children. Children were parents' physical and legal property for many, many, many years, for centuries. Remember at the very beginning of the semester, way back in Module 1, we talked about medieval violence? Well, we didn't spend a lot of time on it then because we were talking about domestic violence and interpersonal violence between adults. But there's evidence back then in legal books and in court cases where parents are declared to be the legal owners of their children in the same way that people who were enslaved were declared to be the property of their owners. So not only were, parents considered to be their parents and therefore had more rights to those children than anyone else, they were actually considered the owners of the children. So what does that mean? It means you could do whatever you wanted to them. In the same way you could kill your own cow, you could kill your own child. And there was no penalties for that in the law for hundreds of years. That may be part of the issue today. There may still be this perception that you can do what you want to your kid. And even though we don't encourage parents killing their children, and we've certainly made many laws about it, we're not going to punish parents as severely because, after all, it is their own kid. But I don't think that's the primary reason for what the researchers discovered when their data revealed parents get 25% less prison time. I think the two reasons really responsible for that are these. The first are constitutional issues. If you've taken, obviously, constitutional law at Hudson Valley, or you've taken or are going to take criminal procedural law, or introduction to criminal law, or even introduction to criminal justice, all these classes we spend a lot of time talking about the Constitution and constitutionally granted rights. And one of those constitutionally granted rights is people accused of crimes in this country who go to trial have a right to face their accuser. They have a right to know and to look at and to question who's ever accused them of a crime. And there's no exception in the Constitution for that victim accusing them of a crime being a child or even being a young child. So in the case of child abuse going to criminal court, the abused child would have to testify in court. The abused child would have to take the witness stand and swear to tell the truth, just like an adult would, and would have to answer questions from the prosecutor about what happened to them. And then they're going to have to face cross-examination from the defendant's attorney, meaning they're going to get questioned about, is that really true? Did you make that up? Did you dream it? Is that really what happened? Have you ever told a lie? All of the very accusatory questions we're familiar with from cross-examination. So there's two issues here constitutionally. One is that an abused child would have to testify in court. In a case where the child's actually been murdered, a sibling of the deceased child may have to testify. Another sibling may be the only witness to what happened and how that child died. So you can imagine, this is incredibly traumatizing for children. It's traumatizing for adults who are properly prepared for it. It is incredibly difficult to take the witness stand and have to be stared at or glared at by the person who committed a crime against you. That's incredibly hard for adults. And it's the most often cited reason for an adult not pursuing criminal charges was they did not want to have to testify in court in front of the defendant. So if you can imagine how adults feel in that situation, how you would feel in that situation, it's thousands of times more traumatizing and more difficult for a child. So oftentimes prosecutors are extremely reluctant to put a child through that and make them testify in court. The second common reason is about evidence. So young children are just not the best witnesses. Very young children who are 2, 3, 4, 5 years old are very imaginative. That's one of the beauties of being a child, is being very imaginative. So children who believe in Santa Claus and the Tooth Fairy and think that there's dinosaurs living outside of their house, children who are very creative in that way, cannot be sworn to tell the truth in court. They simply don't understand the difference between telling the truth and telling a lie. We just can't expect very young children to be able to do that. Therefore, very young children, regardless of what's happened to them, are prohibited from testifying in court. Of course, if the victim can't testify in court, that greatly weakens the prosecutor's case. Let's look at children who are a little bit older, say 6, 7, 8, 9, and 10 years old. These children are still highly imaginative, but most of them have the maturity to be able to explain the difference between the truth and a lie. Oftentimes, these kids can state that if you tell a lie, it means saying something that's not true or making something up. And most of them can also explain that you can get in trouble for doing that, or that it's wrong, or they've been taught that it's wrong to not tell the truth. However, even children who are a little older and a little more mature, who can be what we're called sworn or swearable, meaning they can be given and take an oath to tell the truth, they're still not great witnesses. Children are famous for not having a good sense of time or spatial relationships, right? So if you ask an 8, a 9-year-old when their birthday is, they oftentimes have a very difficult time telling you whether their birthday's in a month or 6 months or 10 months. They oftentimes have a very difficult time, even in general time, describing whether something happened, for example, before Thanksgiving or after Thanksgiving. And you may think, well, what's the big deal? If a child could generally describe what happened to them, what difference does it make if they can actually state the day and the time? Well, this evidentiary issue goes back to the constitutional issue. People have a constitutional right to be informed of exactly what they were accused of doing, and that includes dates and times. Now, even adult witnesses can't always have perfect recollection about dates and times, but adult witnesses are much better at narrowing down time frames, being able to say it was either before this date or after this date, or I know it happened in the first week of April, where young children, 6 to 10, 11 years old, really aren't great at doing that. So you're not going to have a prosecutor put a child on the stand and have them swear to an oath to tell the truth and then just be shredded by a defense attorney on the stand when they get the child to reveal in front of a jury that they really have no sense of when something happened. So that's another reason a prosecutor is going to be very reluctant to put a child on the stand. And children who are, tweens and teenagers, 12, 13, 14, 15, 16, 17, yes, these children by and large are much better at indicating when something happened. Most of them are walking around with supercomputers in their hands, known as cell phones, and are very good at keeping track of times and dates and knowing when things occurred. But the problem with these kids is you still don't want to put them on the witness stand. A child who's been physically abused is going to be terrified, absolutely terrified of the person who abused them. The child may be in foster care at this point or otherwise removed from their care and placed with another relative. They may finally have just begun to achieve some normalcy in their life. And now, a year or 2 years after an event, they're going to be forced to sit in a witness stand and have that person who hurt them stare at them while they once again have to relive what happened to them. So whether it's because the children are incapable of remembering and properly describing events, whether they're incapable of telling the difference between the truth or a lie, whether they're a little older but still aren't really great at explaining times and dates, or whether they're a teenager who can both swear to tell the truth and describe events exactly as they occurred, we don't want to have any of these children re-experience what's probably the worst thing that ever happened to them. So the number one reason prosecutors lower charges and get a parent who's killed or abused their child to just plead guilty is so they don't have to have a child testify in court. So let's do a few examples here where we examine whether something was an accident, it was child neglect, which you learned a lot about in the last module, or whether it's child abuse. So remember, the definition of child abuse excludes accidental injuries. Remember, each part of those definitions regarding physical actions talked about non-accidental injury. And even our neglect definition Although it doesn't use the word non-accidental, it's really focused on a parent intentionally doing something to a child or intentionally failing to do something for a child, like not taking them for medical care. But the law doesn't really intend to hold parents responsible for injuries that are inflicted on their child as the result of pure accidents. Children are frequently injured, even fatally, in their own homes, in cars, or in other types of accidents. And it's really no one's fault, legally or otherwise. I remember many years ago in Menands, right outside of downtown Albany, near I-87, or I'm sorry, maybe it's 787 over there. In any case, a mother had a young child who she was holding by the hand, and she had a child on her hip, a little one she was carrying. And she was trying to cross a very busy street. And in doing so, the older child, who I think was 3 or 4, whose hand she was holding, darted out into traffic, and the child was struck and killed by a car. An absolutely devastating case. Well, is this an accident? Is it child neglect or is it child abuse? Well, in order to figure that out, we're going to ask a couple of questions. One is, did the parent put the child at risk for that injury? And if not, it really was an accident, did the parent respond appropriately to the injury? Well, in the case of the poor mother on 787 in Menands, that clearly was an accident. She did not in any way intend to have her child struck and killed by a car. She was simply trying to cross the street. But let's look at some different examples. I want you to think about what you know about neglect and its definition, and child abuse and its definition. A parent puts a scalding cup of hot coffee on the kitchen counter. The 2-year-old child reaches up, knocks over the hot coffee, and spills it on himself. Parent A. This parent immediately calls 911, puts cold cloths on the child while waiting for emergency medical services. The parent stays with the child in the hospital, and the hospital staff reports the mom was extremely upset and very worried about her child. So, is this an accident, neglect, or child abuse? What would you say this is? I'd say it's an accident. Parents are allowed to drink coffee. That's something a lot of parents do throughout their day. And putting hot coffee on the kitchen counter is where hot coffee belongs. The fact that the 2-year-old child reached up and spilled it on himself, this is a very common household accident. The parent, in this case the mom who put the coffee there, was not trying to hurt their child, nor were they intentionally putting them in harm's way. More importantly, even though this accident occurred, what did the parent do? They immediately called 911. That's what we want parents to do when their kids have received what could be a serious injury. So she immediately called 911. She stayed with the child in the hospital, and the hospital staff said she was extremely worried about her child. That's how we would expect a parent to be in this situation. So this is not neglect or abuse. This is simply an unfortunate accident. Let's look at that same scenario with a different parent. The parent puts the scalding cup of hot coffee on the kitchen counter. The 2-year-old child reaches up and spills the hot coffee all over himself. But parent B responds by yelling at the child for spilling the coffee, doesn't treat the child, doesn't look to see if they're burned, and tells him to sit on the couch. And several days later at daycare, a minor temporary burn mark is discovered on the child. Is this an accident, neglect, or abuse? This is neglect. Now, it started off as an accident, right? The parent just put their coffee on the counter. That's a perfectly reasonable thing to do. They didn't know the child would reach up and spill the hot coffee on himself. But once the accident did occur, how did the parent respond? Well, what they didn't do was get the child immediate medical treatment. When any child, especially a 2-year-old child, receives what could be a potentially serious burn, immediate medical attention is required. And remember, our neglect definition specifically said that children are entitled to receive medical care from their parents who are legally responsible for them. So note in this scenario, I specifically told you that this was a minor burn and it was a temporary mark. So those sorts of injuries are not going to qualify as child abuse. We know from going through that definition how serious an injury has to be for it to be classified as child abuse. So this is neglect. Although it was an accident, the parent did not respond the way a reasonable parent should. They did not get the child immediate medical care, so it's neglect. It's not abuse because the child did not die, did not come close to dying. They did not receive a serious physical injury, nor did they impair their use of a bodily organ, nor did they have a permanent disfigurement. So therefore, this fits the definition of neglect and not abuse. Again, same scenario. Parent puts that cup of hot coffee up on the counter and the 2-year-old child reaches up, spills it all over himself. This is how parent C responds. Parent C gets extremely angry, grabs the rest of the pot that contains all the rest of the coffee, and intentionally throws it on the child. The child is seriously burned and has permanent scars. This an accident, neglect, or abuse? Well, I bet you already know where this is heading. This is clearly abuse. The parent intentionally caused the child to receive a permanent injury by purposefully throwing scalding hot coffee on them. This puts a child at substantial risk of death and permanent injury. So this perfectly fits our definition of child abuse, not neglect. So this takes us to the end of the lecture for Module 10, but of course, you're not done, right? So you have a couple items to do this week. There is no textbook reading, so you can skip that. You have 2 medium items. One is a medium item about the Daquan Parker case. You're going to read more about his plea, which happened recently. And you're also going to learn a bit more about the Michael Valva and Angela Polina case. That's the one from Long Island where the child was left hypothermic and ultimately died. In your project this week, it's a little different than the formal writing requirement, which I'm sure you'll be glad of. You still have to work hard on it, and I'm going to give you plenty of time to work hard on it because you don't have too much to do in this module. But you're going to research and describe a case of child abuse, and you'll see the specific instructions for that in the module. And don't forget, you have a quiz this week due by Monday night. And as I warned you many times, it's on Module 9 and Module 10. So I'm giving you a little less work to do this week. However, I really want you to devote sufficient time to that research project and studying for that quiz, which includes information from 9 and Module 10. And this week you have another opportunity for extra credit just by posting a quick answer on the discussion board. If you have any questions or concerns or anything comes up, please send me an email.